Hello aspirants, welcome back to Where I Is. We are studying about Indian polity. So in Indian polity, we started with fundamental rights. In fundamental rights, we studied that there are 6 fundamental rights. So the first one is right to equality, which is from Article 14 to 18. The next fundamental right is right to freedom, which is from Articles 19 to 22. We had already studied Article 19 in our previous video lectures. Article 20 is also covered in our previous video lecture. That is, Article 20 is giving some kind of safeguard or protection to the accused. It says there shall be no ex post facto criminal law. It says there shall be no double jeopardy, and also it says there shall be no self-incrimination. The meaning of each term we had already studied in our previous video lecture. Now we shall start with Article 21. So Article 21 says, that is, it is providing for right to life and personal liberty. Article 21 is just the right to life and personal liberty. That is, it says, no person shall be deprived of his right to life and personal liberty except by a procedure established by law. Yes, Article 21 is providing for right to life and personal liberty. At the same time, it is not absolute. That is, you can take away the right to life and personal liberty. That is by law. So, law can take away the right that is given under Article 21, that is right to life and personal liberty. Next, right to life and personal liberty is nowhere defined in our constitution. And right to life, it is like foundation for all other rights, right? Because see, without right to life, it is meaningless to have any other right. Without right to life, it is meaningless to enjoy any other rights. So Article 21 is the foundation for all other fundamental rights. Article 21 is not absolute, I had already said, because Article 21 can be taken away by law. It is saying about the procedure established by law. This term, procedure established by law, is not defined in Constitution. Then what is the meaning of this procedure established by law? See, procedure is just checked. That is, whether the law-making procedure is followed or not is checked. That's it. Take for example, that is, whether the law-making authority is competent to make such law is only checked. The intention behind the law is not checked. That is the meaning of procedure established by law. Just the procedure of the law is checked, but not whether the law intention behind the law formulation is not checked. That is, not whether the law is fair or not is checked, only the procedure is checked. This procedure established by law, this term was taken by Japanese constitution, whereas the concept of procedure established by law was taken by Britain. See, here the intention behind or the purpose of the law is not checked. It is not checking whether the intention behind formulating such a law is just or fair or unbiased. That purpose is not checked, right? So it seems a kind of we are giving lot of authority to the legislature, right? So to curtail that, we started with due process of law as well. So India started following due process of law. So due process of law means the intention or the purpose behind the law is also checked. So this due process of law was taken from American Constitution. This due process of law is enforced through the principles of natural justice. Then what are these principles of natural justice? This principles of natural justice, this was made as a part of Article 21 through the Maneka Gandhi versus Union of India case. So what are these principles of natural justice? It says two things. First thing is, hear both the sides in presence of each other. That is, take for example, in a dispute, if there are two parties, then two parties also should be heard, and that too in the presence of each other. So that is the first principle of natural justice. The second principle is, it says recusal of judges. That is, a person who is accused, that person himself can't be a judge for his own case. That is the meaning of recusal of judges, and this is the second principle of natural justice. So the due process of law is enforced through the principles of natural justice. And Article 21 is most interpreted right of judiciary. So every time the court interpreted Article 21, and there were a lot of rights that were made part of Article 21. So at present, there are more than 26 rights which are part of Article 21. Take for example, the right to privacy, which was given by the case, Puttaswamy case, and recently the right to marry of one's own choice was also made as a part of Article 21 through the Hadia case. And also we have right to pollution free environment. All these rights under Article 21 are important. Next we have is Article 21A. Article 21A was added through the 86th Constitutional Amendment Act of 2002. What is this Article 21A all about? It is providing for free and compulsory education to all children of 6 to 14 years. So here it is providing for free education and also compulsory education for all the children of 6 to 14 years. That is, it is providing for elementary education. Here, one thing to be noted is only the elementary education is made as the fundamental right. And this free and compulsory education is implemented through the Right to Education Act of 2009. So this completes Article 21. So Article 21 and Article 21A. In the later classes, we shall study about Article 22. For more videos, keep watching Where IAS and please subscribe, share Where IAS.